She's so fine. Hell of a hell of a blows my mind. Hell of a hell of a lights my day.
What's good, guys? Today is Sunday, January 22nd, 2023. This video will be regarding the Shanquella Robinson case. And specifically, I wanted to show you guys the actual law that actually does say that Dejanay Jackson can be prosecuted in the United States. I had a couple of questions regarding this, I think under my last video. And so I just wanted to do a video to show everybody at one time exactly what the law says in regards to this. So let's get into it. Now, this is coming from the United States Department of Justice website under Title IX Criminal. It is a criminal offense under this section for a U.S. national to murder another U.S. national outside the United States if the murder occurred within the jurisdiction of a foreign country. There are several statutory limitations to this type of prosecution. Before a prosecution can be initiated or started, the Attorney General, who I will refer to as the AG, Deputy Attorney General, or Assistant Attorney General, must provide written approval. This approval cannot be granted if a foreign country has already prosecuted the alleged killer for the same conduct. Additionally, approval can only be granted if the AG makes a determination after consultation with the Secretary of State that the killing took place in a country in which the suspect is no longer present, and that the foreign country lacks the ability to lawfully secure the person's return. Now, yes, we do have laws, a set of standards that we must abide by while we're here in our country. But we also have to abide by those same rules and laws when we go elsewhere, where that long arm of the law that they speak about will reach out and touch you, and it's not something that you want to ever be familiar with. But what this is saying is that yes, in fact, Dejanay Jackson can be prosecuted here, but there are several things that have to take place in order for that to happen. It says that before a prosecution could even be initiated, the AG, the Deputy AG, or the Assistant AG must provide written approval. And that approval cannot and will not be granted if the other country, which is Mexico in this case, has already prosecuted Dejanay Jackson for that same crime. That's kind of like a double jeopardy thing. Additionally, they will only approve this if the AG makes a determination after talking with the Secretary of State that the killing took place in a country, Mexico in this case, in which the suspect is no longer present, which she is not apparently, or we're going to go on that she is not. So she satisfies that little clause. And that the foreign country lacks the ability to lawfully secure the person's return. That's kind of questionable. Does Mexico lack the ability to lawfully secure Dejanay Jackson's return back to Mexico? You know, that's not our call. Goes on to say, the AG has delegated these statutory determinations and approvals to the Assistant AG for the Criminal Division. The Human Rights and Special Prosecutions section has been designated as the Criminal Division's point of contact for all matters regarding the process of obtaining AG, Assistant AG approval to prosecute pursuant to 18 United States Code Section 1119. Now, let's take a look at 18 USC Section 1119. Now, this is from Cornell Law School, but it is 18 U.S. Code Section 1119, foreign murder of United States nationals. Definition. In this section, national of the U.S. has the meaning stated in Section 101A 22 of the Immigration and Nationality Act. We do know that Dejanay Jackson is a national of the United States. We don't even have to go through that. Offense. A person who, being a national of the U.S., kills or attempts to kill a national of the U.S., while such national is outside of the U.S., but within the jurisdiction of another country, shall be punished as provided under sections 1111, 1112, and 1113. Well, that did happen. I think what we're going to get into there is the mens rea, or the intent of Dejanay Jackson in this attack. I think that's what it's going to come down to in this clause, specifically just looking at it. Mexico's already decided this was femicide, point blank, period. Okay, so they've already made their mind up. But I can see the United States hem-hawing around on this. C. Limitations on prosecution. No prosecution may be instituted against any person under this section, except under the written approval of the AG, the Deputy AG, or the Assistant AG, which function of approving prosecutions may not be delegated. So in other words, they can't give it to somebody else to decide. They have to make the decision themselves. No prosecution shall be approved if prosecution has been previously undertaken by a foreign country for the same conduct. So if Dejanay Jackson goes to Mexico and they prosecute her there and she's found not guilty, she can't come here and then the United States say, we're going to prosecute her here. It doesn't work like that. That cannot happen. Not for the same charge. Let me reiterate that. Not for the same charge. No prosecution shall be approved under this section unless the AG, in consultation with the Secretary of State, determines that the conduct took place in a country in which the person is no longer present, and the country lacks the ability to lawfully secure the person's return. A determination by the AG under this paragraph is not subject to judicial review. Now, this article goes on to say the department has formally approved several Section 1119 prosecutions, including the following reported cases: US versus White, coming out of California in 1997, US versus Nipper, coming out of Louisiana in 2002, US versus Wharton, coming from the Fifth Circuit Court of Appeals in 2003, United States versus Bremiger, coming out of California in 2015. These reported decisions upheld the government's use of the statute and held that the AG's determination regarding the statutory requirements contained within Section 1119 is not judicially reviewable. The department has taken positions in previous Section 1119 matters regarding several aspects of the statute, including when a foreign country has previously undertaken a prosecution, the meaning of same conduct, when a certain foreign country may lack the ability to lawfully secure a defendant's return to that country to be prosecuted, and the applicability of the statutory limitations in Section 1119 to a conspiracy to commit a foreign murder pursuant to 18 United States Code Section 1117. Any USAO or other department component seeking approval to bring a Section 1119 prosecution shall promptly notify HRSP and submit a written request well in advance of the proposed prosecution. The written request should include a prosecution memorandum, a copy of the proposed indictment, information, complaint, a detailed explanation as to the federal interest in prosecution, and a proposed timeline for submission of the indictment, superseding indictment to the grand jury. HRSP has collected information and resources regarding prosecutions pursuant to Section 1119, and any office seeking approval is encouraged to seek informal advice from HRSP before submitting a request for approval. The office submitting the request should allocate sufficient lead time to permit review, revision, discussion, and coordination with the Secretary of State before scheduling the grand jury. I wanted to bring this forward as well, in all fairness. It says the U.S. Supreme Court determined in Heath v. Alabama, 472 U.S. 82, 1985, that the Double Jeopardy Clause of the U.S. Constitution is applied separately with regard to each sovereign involved, and that each state and the federal government count as separate sovereigns. In the pertinent part, it states, the dual sovereignty doctrine is founded on the common law conception of crime as an offense against the sovereignty of the government. When a defendant in a single act violates the peace and dignity of two sovereigns by breaking the laws of each, he has committed two distinct offenses. U.S. v. Lanza from 1922. As the court explained in Moore v. Illinois, an offense in its legal signification means the transgression of a law. Consequently, when the same act transgresses the laws of two sovereigns, it cannot be truly averred that the offender has been twice punished for the same offense, but only that by one act he has committed two offenses for each of which he is justly punishable. In practice, though, the U.S. Justice Department and most state and local prosecutors are disinclined to prosecute a crime that has already been handled by another jurisdiction, and often have official but non-binding policies to that effect. In part, this is because an acquittal in one jurisdiction makes it likely that it is a weak case, while a conviction in one jurisdiction often constitutes sufficient punishment. There could be an issue under the Eighth Amendment to the U.S. Constitution, cruel and unusual punishment, over whether a punishment imposed in a U.S. conviction for a crime needs to consider the already severe punishment imposed in another jurisdiction for the same crime in order to prevent the cumulative punishment from being cruel and unusual. This person says, but I am not aware of authoritative case law that resolves that constitutional question. So is it possible for the U.S. to prosecute Daejhanae Jackson for what happened to Shanquella Robinson? Yes, it is possible. But, I'm going to say it, but, Mexico has already came up with the charge, femicide. Here, we would get into the whole mens rea intent behind this attack. Did Daejhanae Jackson intend to kill Shanquella Robinson? And I think it would get rather messy. It seems like Mexico is dead set on femicide. They never budged on that charge. Have yet to budge on that charge. Have it very well set forth and have spoke about this charge of femicide. So it looks like Mexico is interested in prosecuting this case, and I think it would be a big slap in the face if the U.S. at this point decided to say, hey, we're going to prosecute Daejhanae Jackson, because Mexico has already done their investigation and are continuing to do their investigation and have went so far as to request Interpol assistance for Daejhanae Jackson to be put on the red notice list, to have her extradited. They want her back on Mexican soil. They want to prosecute this case. Now, if they didn't, it'd be a whole different ballgame. But they are very interested in prosecuting this case and have expressed that interest multiple times. So I just don't see any way that the U.S. is going to do it. But can they? Absolutely. Yes, they can. So I just wanted to come on here and just answer that. And I'm going to end it on that note. Thanks for watching, guys. Have a great day.